In the courtroom, I stand bold. Self-represent, watch the truth unfold, yeah. Moorish knowledge, writs on hold, gavel banging, but my plea is cold, yeah. Law book stack, I'm my own advocate. Govern itself, they can't manipulate. 2, sovereign moves, no attorney fees.
Yo, peace. Barghani, Islam, Salam, Etepu, Rahubat. Gino Lako Ninani, Chief Noble Bandele, Elamine back in the building. And you know it's Pro Se More, so I got King El Bay in the building with me. What's going on, my brother?
What's going on? Peace and love to the family. Yeah. The Pro Se Moors in the building, the dynamic duo transformed into a Pro Se litigant with all the powers to move the court.
Hey, so y'all, peace and love, man. We back in the building, man. We here again for another episode of the Pro Se Moors. Today we're gonna be dealing with motion pleading. Okay, so we're gonna get into the motion pleading. I would imagine plea bargaining and all the things that come along with it, right? So that's what we're gonna get into tonight. But before we get into that, I'm just gonna drop an ad on y'all real quick before we get into this. All right, so let's go.
Books are taught, words are from the motherland. Ancient scripts in my hand reclaim that stolen sand. Moorish tales, knowledge based in masses. Both hearts breaking chains and shattering the glasses. African censored, knowledge spread up blazing. Moorish conscious, mind sharp, yeah we're raising. Foot on fire, history in the making. Smoking nowhere, ain't no more mistaken.
Yes. So y'all can check out all our books on indigenousmoors.org, and you can also find our books on Amazon.com. So please go check our books out. Check us out, right? So
also, before you get started, I want them to see the background, right? I got a new book coming out for the spring. It's Legal Principles, the DNA of the legal system. We're going to be breaking this down, showing you all how the legal system, how it's supposed to look through operation of law, application of law, source of law, the rules of law, and how the principles construct the legal system. So we're going to show how there's 2 legal systems in the United States. We're going to break it all the way down. So now you will have the proper information and you will see the functionality as a court based on these legal principles. So it's coming soon. It's with King El Bay and Abdullah Mosley Bay, Talib, Abdullah Mosley Talib Bay. So check us out. We're coming with some hard information so y'all can get a grip on this legal stuff so you can weaponize your mind to be a proper jurist.
Yes, sir. Y'all hear that, man? Y'all look out for that book. You know it's gonna be hard. You know they're gonna drop them jewels. So I already know how it's gonna get down. So without any further ado, anything else you wanted to talk about real quick? I know you drop about the petition real quick.
Everyone, we're back on the road to sovereignty. We putting a petition together. We're trying to get at least 10,000, but if we can get enough people to sign, so this is one of the elements necessary under the application of law sovereignty for us to be able to, as indigenous, autochthonous population, to be identifying ourselves as a permanent population under such application of law as a fundamental exercise of a right. This is a fundamental right, or a fundamental right to exercise. So we try to get 10,000 members so that we can start bridging and start making this become back a part of being politically legitimate to now move into a provisional state of government so that we can start really actually controlling our own affairs. So we're teaching, over here, we're breaking it down. We're not teaching pseudo law. We're not teaching status correction, secure party creditor, all of these misnomers or concepts of law. We putting everything back into law based on true and real application so that y'all can understand it. Because the movement has been, it's been how they have allowed a lot of people to tokenize phrases and create processes that's not applicable to law outside of the legal language, which now it can't be identified, in which you can't get a remedy. So if you don't come within the law, if you use the language outside the construction of the law, the substantive language, you can't get a remedy. So you have to understand that.
Yes, sir. Yes, sir. So you hear what we going on. You hear what we trying to do, man. We trying to put this work in. We got to get things back in order. And so when y'all see the road back to sovereignty, understand that is dealing with the petition. In order to put things back in place, to petition our status, our way of life, all that, right? So we got to put that down. So just be on the lookout for that, right? All right. So with that being said, man, where you want to start? You want to start with what? Pleading, plea bargaining?
We're going to start with motions. We're going to start educating people how to properly move the court with a motion.
Okay,
and
so
what needs to be addressed in motion pleading, right? The issue, a lot of us, when we don't understand the application. We don't understand the application process. So what we'll do is we'll create things that's outside of the substantive language of the Constitution or any civil authority under any code, statute, ordinance, or anything. So we'll make up some things that's not fundamentally sound. So now it's outside the scope of the court, and they can't truly make a decision. So they see that it's frivolous, or they see that it's not applicable, improper venue, all these other things that, due to not being able to understand what you need to be critically thinking about, thinking proper when dealing with motions. So we first got to understand how to deal with emotion. So you got to come with the proper application. So if it's a constitutional application under the first 10, right? Go ahead, ask me.
No, I'll go. Well, explain to the people, man. We know this is Pro Se Moors, man, 101. So explain to the people what are you talking about as far as motions. What is a motion? What's the purpose of a motion?
Okay, a motion is that it's an instrument or a document that you're asking the court to do something in relationship that's constructed by either the procedures or the rules of the court or a principle of law rooted in legal principles, rooted in application of law, depending on if it's a constitutional application.
All right. Okay, you muted.
Yeah.
So I'm gonna look at you. Go ahead.
Okay, go ahead.
No, go ahead. Go ahead. You good? I was just
So
going to explain it.
when you're talking about motions, you gotta where are you coming from? What are you pulling the source? What is the source of law that you're applying? Is it a statute? Is it a code? Is it an ordinance? Is it a procedure? Is it a rule of the court? Is it a principle or a doctrine? What is the application in which you're looking for? So, like, for example, if we're looking for Brady discovery, the case law is the application. That's the constitutional application in which the court had created this rule based on a doctrine. It's based on a principle. Now, this doctrine is now, the Brady discovery is a principle of law in which, under the common law, that you pull in the constitutionality of what you're trying to get done in accordance to the Sixth Amendment. So it's a Sixth Amendment application based on a set of principles and standards that has a particular set of elements that you can ask, do, and relate it in accordance to the procedure that you're asking for a motion in accordance to the civil rules or criminal rules. So you must understand these things and how this stuff works so that you can properly move the court, right? When you don't understand the law and the legal functionality, we get outside of the scope of law, and the court cannot hear that. They don't know how to approach that. So when I like to argue in dealing with the court issues in most proper, teaching people how to appropriate or proper motion plead. Don't start arguing things that's outside of the court scope or jurisdiction. Because for one, when we're looking at venue, you got to understand the venue you in. So if you're in a improper venue, that needs to be.
You're muted again. You there? Oh, okay. I think he dropped off real quick. I'm sure he'll be back on in a minute. But while he's doing that, I just wanted to, before he get all, because my man, King, we do this, and so he can go in, right? But what I wanted to look at, I just wanted for y'all to understand the motions. A lot of times we don't understand the motion thing, right? So one of the things it's saying is a motion is an application, which he talked about, but it's the application to the court made by a prosecutor or defense attorney or a pro se litigant, right? Requesting that the court make a decision on a certain issue before trial begins. So most of the time motions are done, before trial. So I'm gonna see, hold on, let me see if he's back on. There we go. All right.
Yeah, I don't know. I got to talking and it is, I don't know.
Yeah, I don't know. I was just trying to get, because I know you were starting to go, and you was kind of getting away from the motion and explaining to them exactly what a motion is. So I just kind of filled in a little bit on that and was just we was just looking at the definition of it.
Okay. So you got to also remember there's different motions according to the phase of what you're in. You have pre-trial motions, right? These are preliminary motions. And you have post-trial motions. These are the two motions. So this is one before trial and one after trial, right? Because you have those, right? So understanding the proper phase, because there's a lot of moving parts that you got to be able to absorb and understand. So your preliminary motions, right? You can do all types of things in that motion. And what you want to do is stimulate the court based on some rules, okay, based on application or principles of law in which you can get the court to move upon. So it can be according to a criminal rule, a civil rule that's in conjunction with a procedure the criminal rules, civil rules, under those procedural contexts. Then you have application under treaty, under the Bill of Rights, right? Not treaty, under Constitution. I'm all over the place. I'm sorry. So let me refine tune this as what I'm saying. You can put motions in accordance to procedures, criminal rules, civil rules, superintendent rules, rules of evidence. There's many different rules. You got court rules. Then you have constitutionality or constitutional applications according to the Constitution and any under those first Bill of Rights, first 10, and even the 14th Amendment and some of the others. Under that, put a motion into that. Then you can put other motions in according to treaty. If there was a treaty application, but it must be within the proper venue. So the United States wouldn't be the venue that you put it in. You would have to put it into a international court that's able to hear that treaty. So then you have international public law and international private law. So international private law is bilateral treaties that's between two treaty parties, and the private party must move for the enforcement of the action on its own. So a lot of us has just got a lot of different misconceptions of how this stuff works. And then we talk about venue. Gotta always consider venue. What subject matter can be heard? So you gotta look at the court and to determine if this court can even hear certain things based on that. So if you're in a traffic court, they're not traffic. Remember, it's traffic. The criminal rules are applicable, but the dominating jurisdiction is traffic. They're not dealing with rape, murder cases. They're dealing with traffic. It's traffic court. Then you got criminal or common pleas in my state courts. And traffic court falls under the common pleas. So then you have civil, right? We're talking about civil. So when you say traffic court, I want you to understand that the primary rules that govern traffic court is the traffic rules of procedure. But what's also applicable is the criminal and civil rules, right? Those rules are also applicable, but they should be applicable in conjunction with the traffic rules. So y'all need to understand, the first is the traffic rules, and you tie it in to the criminal or civil rules. But you have to look at the language in the traffic rules to do what? To substantiate the right to exercise a criminal or civil rule. If you're
this is all dealing with the motions, right? You're talking about
dealing with the motions. So if you ask the court to deal with a civil action that you don't identify by the traffic rules, it can be void. Because you didn't show the application of law and how it's being used. You're saying, okay, I'm doing this in accordance to traffic rule 57 or traffic rule 27, that this based on the substantive language in this traffic rule, I can now invoke the criminal and civil rules in which I've done to do what? To be able to move the court in accordance to these other rules. Now you lay out your claim in accordance. Now you can put a case law that substantiate that, right? So under the common law, you can say under the common law, under this, if it's a discovery, under Brady discovery in accordance to the Sixth Amendment, an application of the Sixth Amendment, incorporating these rules, the court give instructions on how to utilize the traffic rules in conjunction with the civil, criminal, and civil rules, in which now sets a precedence for me to use such application in this manner. So you show in the court that you understand how the law and the functionality of the law, in which now you can put these things together. Okay. So, you have to be a very sophisticated litigator. That's why we put together indigenous services for everyone who trying to be a part, who need understanding about some of this information. Understanding we don't give legal advice. It's just for us to educate you on how to think about everything, to think proper. So, it's entertainment, and we do.
I like to call it edutainment.
Yeah, edutainment, right. So for edutainment purposes. So that's our purpose. But we break it down. So you need to understand these components. So you got your pre-trial motions. These are the things you're going to do prior to trial. Motion for discovery. You might do a demurred plea. You might do, some states
motion to suppress. Motion to suppress.
A motion for supplementary discovery after receiving discovery. A motion in limine, where you don't allow this. A motion to strike. evidence, a motion to strike. You can do all of that. You can do a subpoena, do a motion for subpoena, ducus tecum, a motion for subpoena, right? To inform with the subpoena, right? You can do a notice, right? Judicial notice. You can do a motion for judicial notice and put in the judicial notice. So it's a lot of things you can do in with that, right? Then you have your affidavits that's in support of your motions,
Right.
right? We're going to talk about affidavits and how to properly use affidavits with the motions, right? So you can do an affidavit in lieu, right, of that.
Before you get into that, let's explain, to the people about affidavits and emotions, because a lot of our Moorish brothers don't want to file motions. They want to file affidavits instead in court. They want to just file an affidavit. So explain to them like why it's important for a motion, and let's clear up some of the misconceptions around using a motion, because they say if you use a motion, you're in their jurisdiction. You want to do an affidavit. So explain that to them.
So, okay. So affidavits do not do anything. The only reason you are in the court, because the court has made a determination that you are in the jurisdiction, that your status allowed them to be in the jurisdiction. So a lot of people talk about the status correction and it's going to kill. No, it don't. So that's another topic about status. We'll do a video on that. But the court already made a determination. Most of you guys either had a driver's license or still carrying a driver's license. So based on that, your status automatically allows them to have jurisdiction. So let's look at this in relationship to what is going on with affidavits. Most people are trying to use an affidavit to say they don't have jurisdiction or to challenge the jurisdiction. But that's not how you do it. You either deal with the court, and the court can only hear you by motions or writs. They only can hear motions, I want to say this again, or a writ.
Check.
That's the only time they can hear you. They won't entertain an affidavit. They don't hear affidavits. Why? Because the affidavit has to be authenticated. Affidavits are what they call evidentiary tools. It's an evidence tool. So the courts only can hear. Just because you appear in court don't make the court be able to hear you. Now, if you're trying to say the court don't got jurisdiction, that means you have to motion the court to move to a different venue. But that's when they hear you. If you put in affidavits, they're not going to entertain it. They're not going to, because you didn't request the court to do anything. I know that you're trying to say, well, y'all don't got jurisdiction, but y'all don't go up. That's not how to go about it. A lot of y'all, so many of y'all challenge the jurisdiction, don't know how to understand how to this work. They already made the status determination, or you wouldn't be in the court at all. And if you was in court, then you would have to move the court to a proper venue to hear the things for the court to dismiss the action based on improper venue. So these are things that you need to understand. So once again, y'all need to understand the purpose of an affidavit. Affidavit, for one, has to be authenticated. So if you put in an affidavit and you use the sources, other people's sources or whatever, you have to state that you have firsthand knowledge of whatever's going on. Because if you use somebody else's or you state something, case law or everything, that's not firsthand knowledge. You understand? If you claiming that you are more and you this, that, and the third about your Moorish status, what you have to do is you have to have somebody come and authenticate your record, a government, a Moorish government, that say that you're a national, because the only way citizenship, we're talking about status, we're talking about citizenry, we're talking about citizen and naturalization and immigration. Under the law of naturalization, immigration, and citizenship, there's elements that need to be identified. Did you make a pledge of allegiance for protection? You saying that you are part and parcel based on your contract that you made with said government. So things they're using these things based on a lot of different areas. So one of y'all need to understand what I'm gonna talk about real quick, and I ain't gonna go into a long. I don't want to get into no long discussion about it. Selective service. Y'all go get you a driver's license, and you don't know that you signed up for the selective service. So when you sign up for the selective service, you join the military. Ain't nobody teaching y'all that. So now they got jurisdiction. And anytime you sign up for anybody's military, you just expatriated from one government to another. So it don't even make a difference. So y'all got to understand the motion plea. If you're in the court, they already presume that they got jurisdiction. And if you challenge the jurisdiction, make it a constitutional challenge based on a question, constitutional question. All of this lack of jurisdiction based on subject matter, a venue, a proper venue. These are the things that you need to understand. All this stuff, the pseudo law about, people don't understand. So we got to understand how to properly motion plead. So no more affidavits. Affidavits in conjunction. Now, if you want to do an affidavit,
right, that's where you was going with it. I just wanted you to jump in on that.
With the motion, in support of said motion, that's fine. So we like to use a motion and an affidavit in support, right? Breaking all the elements down, meeting the elements of the application that we're asking. If it's a motion to dismiss, we're going to use the affidavit to show the reasons why the motion to dismiss is, we got grounds for it, and the exhibits that support all the findings of facts. So we know how to do this in conjunction. Most people don't do that. Y'all put y'all motions in, y'all don't have an affidavit in support of your motions or the exhibits that support the motion and the affidavit. Most of y'all don't do that. Most of y'all don't understand that. Most of y'all don't understand that litigation prowess to drive your point home, because because once you break that down and you put it in that kind of motion, guess who had to respond to that motion? The opposing party. So I like to do that all the time, and a lot of times what I found out, the prosecution don't even motion plead like that. They don't have no supporting affidavits or no exhibits. They'll put in an affidavit. Most of the time, when I motion plead like that, they don't even respond. So I asked the court from the beginning, okay, prosecution had to respond to this motion. I'm asking that they had 30 days to respond to the motion. So I'm asking for the relief granted because they didn't even address the motion. So the court, if they don't respond to the motion, you can ask the court for relief based on that motion, because they had a duty to respond to the motion. A lot of times the judge will skip around that bull, they'll pull you. This is what the court will do. The court will start arguing some bull crap, and the prosecutor over there silent. Prosecutor over there silent. But you going back and forth with the judge. The judge just baited you into a situation, and the prosecutor don't have to do nothing, and the judge is going to move the court. And you ain't even put it on the responsibility on the prosecutor. You ain't addressed the court. saying, Your Honor, I put in a motion for this. I put in, let's say, a motion to dismiss, and I got the grounds for the dismissal and the exhibits to show that I'm entitled to this relief in the case law. Prosecutor over there not saying nothing. The judge going forward trying to set the case for trial. Your Honor, you're not going to do anything. You just going to move the case to trial? I'm object to trial because I'm going to ask for this motion to be dismissed.
Right. Now, let me jump in real quick. Let me jump in. That is one of the major issues, I believe, that we have when we're in court is we'll file motions and the judge does everything he can to get around it. A lot of us, I don't think, know how to argue or to deal with our emotions, like how to get our emotions, read, or how to get our emotions, how to argue our emotion. So I just want you to speak a little bit on that, like how to focus on fighting and arguing your emotions.
So what would you got to remember? They must afford you due process. That's a constitutional guarantee. Okay, they can't get around it. When the court will allow you to be heard on those motions or trying to get around those motions, what happens is they're evading due process. Two things they're doing. They're stopping you from creating a record for appeal, which is ultimately denying you a right to an appeal that violates due process. And they're not giving you a right to be heard, which violates due process altogether. So the issue becomes that if you file a motion and the judge is more argumentative than the prosecutor, you have to stop the judge. You have to inform the court, are you going to allow me to be heard? Or my motion is going to be heard on the ground, so are you going to allow me to get the relief? Because they never responded to the motion. I need you to address the prosecution, Your Honor. For the record, on the record, I'm objecting to any trial proceedings, and I'm asking for the enforcement of my right to be heard. Are you denying my right to be heard? Yes or no? That's just a simple yes or no question. I don't want to go back and forth. If you don't answer the question, we're going to presume that you're saying no. And I would like this to be an issue for the appellate court. And then if they keep doing it, you say, well, Your Honor, here's the issue at hand. I didn't file preliminary motions in which you're not entertaining. You continuously or not allowing me to create a record. You're over talking me. You're being rude in this process. So now I need to file an injunction. I need to file a notice of injunction, or I'm going to put an oral motion of injunction. Your Honor, I'm putting the court on an oral motion for injunction and a motion to stay, an oral motion. Right now on the record. If the court is not recording this, I will do a motion to be filed after 2 or 3 days. I will have a motion in, putting you on notice that I'm going to file a preliminary objection due to these due process issues. And then I'm a ask the appellate court to stay for these violations of due process. Because what I'm going to address the appellate court is based on the court's action. I won't have a record for appeal, which ultimately deny me a right for an appeal, and which is violating my due process. And if I can't introduce evidence or be heard on the motions or get the relief based on those grounds, then the court is not applying due process. And without due process, we only have tyranny. You have to address the appellate court appropriately when you understand these matters, and most people don't. So when I deal with the court, it's a whole nother thing. They know I know what I'm doing. They know it. So they don't talk to me the same way. And then I don't get all upset anymore. I used to be, I don't care about how the judge is getting upset and trying to be forceful. That's not impressive. I'm not scared because I understand knowledge will set you free. So based on the knowledge that I have and based on what I'm confident in my abilities and my comprehension of the law, I just move on to things. It might take me some time. They might tie me up for a while, which is a big inconvenience, right? So but I know what I'm doing. So that set another stage for me, based on properly understanding and how to move the law. Instead of just going in there trying to throw all this stuff, this goofy stuff at them that y'all don't understand. I'm gonna put in the affidavit and I'm gonna challenge the jurisdiction with the affidavit. The court is not going to entertain it because you're not in construction with the rules. You're not in construction with the rules. So the court said you got to put it in motion. Now you could argue Haynes versus Carter, right, where the court don't supposed to construe you as the same as an attorney, right? They got to liberally construe your pleadings. But that has to be argued. You have to put that into that's an application. That's a constitutional application.
Right. So we're talking about motion and pleadings, right? They're not, motion and pleadings are not the same, right? But they go hand in hand.
Yeah, they go hand in hand.
So what is the difference? Like what is the difference between a motion and then pleading? Like
pleading, when you so when you put in the motion is that you're asking the court to do an action. That's action, motion. You want them to do an action. The pleading part is the application itself. In accordance to a rule, the Sixth Amendment, that's the pleading. The case law, that's the pleadings, right? Stare decisis, right? Those things are already, you're pleading to the court to follow the instructions of a higher court when you're dealing with stare decisis, cases that's already been decided and the court's already laid down instructions, so you follow under that equal protection. So you can't, that's why it's called motion pleading. It's hard, you can't plead without motions. It's going to be, you can't do that. So you got to put the court to, you want them to act on your pleadings. So that's the purpose of, they go hand in hand.
So I got this up here, right? So we're talking about pleading, right? So I'm gonna go into a little bit of this and see where we go with this. So it's saying pleading. Pleading is one of the first stages of a lawsuit. In a pleading, the parties formally submit their claims and the defenses against the opposition's claims. The parties can make specific pleas, such as a guilty plea or a not guilty plea. Pleadings usually do not include evidence for and against the claims, which is presented later in the lawsuit. Generally, a plaintiff submits a complaint which states the cause of action, then the defendant submits the answer to the plaintiff's complaint, asserting their defenses and possible denials. Also, if the defendant has a counterclaim against the plaintiff's cause of action, then the defendant submits the counterclaim during the pleading. There could be possible further pleadings after the initial pleading of both parties, including a reply or a rejoinder or a surrejoinder. Okay, I'm going to stop there. Now, was there anything in that you wanted to
identify?
Identify with it, yes.
So, okay, so when we talk about one of the first elements of the pleading is the complaint, right? You're complaining to the court. You're saying, hey, I got a neighbor who is too noisy. So you might file an action against them, right? A civil action. You might put in an injunction for relief, asking the court to, a temporary restraining order. That's an injunction to restrain them from being too noisy. Or you might file a complaint if somebody owe you some money, right? Breach of contract. That's a complaint.
Okay.
Then
and this carries over the criminal too, right? Because like this, we was talking about civil, y'all.
Right.
So this carries on to criminal.
In criminal, the prosecutor is putting in a complaint that you violated a statute. They're saying, okay, he did this against the law, right? So they're going to charge you with a particular statute, right? And that statute is the pleading, right? And then you have various motions within, once the pleading or the complaint is filed, then you have other motion pleadings that's going to, based on the procedural process, how everybody is moving, and if everybody is what? Following the rules, right? The rules of construction. So that nobody can be inadvertently surprised, or evidence that can be used that was never identified, in which now you're being railroaded or something like that. So the purpose of the initial pleadings, right, is the complaint, and then we go into the motion pleadings based on the procedural prowess on various applications of law, in which you're asking the court to enforce that because one party is not adhering to the rules, or these are things that you have a right to actually get in accordance, like discovery, so that you can inspect the evidence. And then you can suppress evidence when evidence has been obtained illegal, and strike evidence that is that's in violation. Or also argue fruit of a poisonous tree, that all the evidence that's being used was based on an illegal search and seizure, that none of the evidence can be used based on a violation of law. So these are other motion pleadings. So you got the complaint, right, that you're asking for relief, and then you're asking your motion pleadings, in which you can be asking for relief under, based on the procedural grounds that the law, that they haven't followed the law and adhered to the rules. So now they don't have a remedy because they outside of the rules.
I got you. Y'all, if y'all in the building, please like this video, y'all. Please subscribe to the channel as well. Please subscribe. All right.
We're heavy hitters. We black in court eyes. We go in there and hit the judge in the eye. Shut up. Pretty big motion.
Okay, man. Okay, so you got anything else? I know you got some stuff that you wanted to put on the screen display.
Yeah. So the first thing I want to talk about is one of the elements is appearance. If I can share the screen, my brother, we're gonna talk about appearance. A lot of people don't understand what appearance is. Okay. I want y'all to understand appearance. Can they see that, Chief?
Yes, sir. You are on. You are live.
So let's look at appearance from every different perspective. In practice, coming into a court as a party to a suit. Coming in as a party, I want you to listen to the elements. You're coming in as a party, whether as a plaintiff or defendant. Stephens versus Ringley, 102 South Carolina 33386. This is court cases. Formally, the formal pleading by which a defendant submits himself to the jurisdiction of the court. So you submit yourself to the jurisdiction of the court. The voluntary submission to a court's jurisdiction. Okay, I understand that. I want you to understand the voluntary. Appearance is the act of appearing, coming, or being in sight, becoming visible or clear to apprehensive of the mind, of being known as subject of observation or comprehension, or as a thing proved or being obvious or manifested. I want that to sink in, everybody.
All right, you're going to have to break it down. Break that down.
Okay. So,
yes, sir.
We're gonna talk about the 14th Amendment, naturalization, right? Three elements. They talk about born, naturalization, or subject. We're talking about subject. When you're a subject, we're talking about a thing. We're talking about property. We're talking about rights. We're talking about all of this, right? So when you come into the court, when we talk about being visible, comprehensive of the mind, or being known as a subject of observation, what is the court talking about? They're saying that based on some contractual element, that you are now subject to the jurisdiction based on observation and comprehension, or as a thing proved, right? This has already been proved. They already proven that they got jurisdiction. This is why I keep trying to tell y'all got to understand this. And you got to have evidence of the presumption, killing the presumption, right? You got to have evidence that kills the presumption of law, right? Because they already established that you are a thing to be proved. So status deal with property. It deals with, persons, places, and things. Status, once again, deals with persons, places, or things. Black is a thing that they identify you by, in which they automatically presume they got jurisdiction. Because it's a manifestation of their mind based on a constructive language in which they use to identify people of color. They use black, white.
Check.
They are the creators and the authors of black and white people. No other country identify you by such identity. The United States does. So it's a corporate or a creature of government because it's manifested through the language and application and on a domestic policy.
Okay. So Brother Tariq, peace, Brother Tariq. He basically asking how has that proved they got jurisdiction? How is that proven they got jurisdiction?
How do they prove they got jurisdiction? Due to certain elements that you didn't bring up. They're using presumption of law. They're presuming that they got jurisdiction based on several grounds. Most of you guys who graduated high school are part of the selective service, right? Or you have a social security number, or you have identifying property that is governed by the United States. The thing itself, the birth certificate, is a thing. Social security card is a thing. The a selective service number is a thing. An EIN number is a thing. You guys will keep saying
this is all property, right? This is all property, correct?
Exactly. It's a thing.
Right. It's a property, which is
intellectual property. It's something that they can construct from the mind through legislation. It's theirs.
Right. That's where I was gonna go. It's the property of the state.
So now you're arguing stuff and you have these things on your person. What do I mean on your person? You're using them. You're personally using them things. Now you're arguing about, oh, y'all don't got jurisdiction. But you have custody of those things. Come on. If you had a driver's license and you under suspension, oh man, I ain't got no driver's license, I'm under suspension. You technically you still have a driver's license, it's just under suspension. That means you are still subjected to the laws.
What would you have to do not to have a driver's license?
You got to rescind it.
Okay,
but that still don't alleviate you from the jurisdiction.
You're right. Because you got all other things. You got all those other things you're using. Go ahead.
So I hear Moors. Oh, I expatriated. What do that mean? Okay, and that's why I say you don't know international law. A stateless person is still subjected to the laws of that country. You just don't have a state. You don't have nobody that's gonna come and get you, no national standing. You don't have a
Stateless-
family of nations. So now
stateless person.
you're a stateless person. You still look up laws on stateless persons under international application and domestic application of law. This is why I keep trying to tell people, when you're outside of the scope of the language of law, you don't get no relief because the court can't do something they don't understand.
Okay.
So let's still continue with appearance. Appearance anciently meant an actual coming into the court. I'm gonna say this again. Appearance anciently meant an actual coming into the court, either in person or by attorney. Appearance may be made by the party in person or by his agent.
Could you blow your screen up a little bit more? There you go. All right.
Appearance anciently meant actual coming into the court, either in person or by attorney. Appearance may be made by the party in person or his agent.
Okay.
Remember, we talked about contracts. Do you want me to talk about that? Or wait. Remember, we were talking about the power of attorney and stuff but that's something.
I mean, you can tie it to that real quick. Like, let's not go into, but like, let's tie it to what you're saying.
Okay, so
appearance by agent.
Okay. So, for example, you can have a contract, right? Power of attorney, a different stuff like that. I ain't gonna get into the whole spiel of what you can do. You can have different agency, right, that represent a trust, right, on a statutory level, right, that could come in and entertain this with an attorney and all of this, and they can make the appearance on your behalf, right? The court may order your appearance personally, depending on the subject matter, if it's criminal or if it's civil. But if it's civil, a lot of times you might not have to be there at all. And really, what we need to understand, there is no civil jurisdiction. There's only a civil system, right? There's only 4 jurisdictions the court deal with. They deal with common law, equity, maritime, and amity. These are the 4 jurisdictions, constitutional jurisdictions. These are the constitutional jurisdictions. Now, there are other jurisdictions, but we're talking about constitutional jurisdictions first. These have to be identified first. Then you have other administrative jurisdictions, right? And this is what a lot of people don't understand. They get it confused. So, but under their administrative banner, they have different jurisdictions. But the first issue at hand, what is the constitutional jurisdiction in which you're going in front of? And then it breaks down to agency, then territory, different stuff like that. You got subject matter, personal jurisdiction, and all of that, right? But first, we got to understand the constitutional jurisdiction before we can get into any of those other jurisdictions based on that. Because the 3 creatures that you're dealing with, those are constitutional creatures, right? And if you go into territory, you're dealing with treaty application. Now you're dealing with national standing. Now you're talking about dealing with a nation. And now you're talking about jurisdiction based on territory, treaty territory, challenging the jurisdiction. Now that's another application of law dealing with international application of jurisdiction, right? We're dealing with that particular subject matter. So the first issue we want to dealing with the constitutional creatures, which is the 3 branches of government, judicial, legislation, and executive branch. You want to address the primary jurisdiction, which is the constitutional. We don't want to get into the secondary jurisdiction based on the administration. You understand what I'm saying? So let's talk about appearance. Appearance may be either general or special. The former is a simple and unqualified or unrestricted submission to the jurisdiction of the court. The latter, a submission to the jurisdiction for some specific purpose only, not for all purposes of the suit. So we're going to talk about bankruptcy court. That is a special or specific. A special appearance is for the purpose of testing the sufficiency of service or the jurisdiction of the court. So we talk about perfection of service. There's elements that the court has to do to perfect service. And then there's elements they have to do to to perfect jurisdiction. This is how you challenge the court constitutionally, because the Constitution guaranteed that they must follow the Constitution and afford you due process, or they do not have a jurisdiction at all if they fail to meet any of their constitutional requirements or requisites or mandates. Okay? A general appearance is made where the defendant waives the defects. Let's see this again. A general appearance is made where the defendant waives defects of service and submits to the jurisdiction. So the court don't have to perfect service when you make a general appearance, right? An appearance may also be compulsory or voluntary. The former where the compelled by process served on the party, the latter where it's entered to by his own will, consent without service of process. Though process may be outstanding, it is said to be optional when entered by a person who intervenes in the action to protect his own interests, though not joined as a party. This is what we talking about, power of attorney. Talking about rights and property. We talking about I ain't gonna spill out the beans. Y'all gonna have to come over to the indigenous services. Get this sauce. Get some of this sauce. It occurs when chancery practice, especially in England, conditional when coupled with conditions as to it becomes or being taken as general appearance. See, they already presume certain things about you. You got to kill it. That's why you got to raise certain issues. You know, you got to tell them, I'm coming special based on the fact the service of process and jurisdiction hasn't been established by perfection due constitutional guarantee. I'm challenging the constitutionality of this case based on the due process issues that's involved, that I'm challenging the court due to those matters. That the court has, the prosecution, not the court, the prosecution hasn't perfected due process. And under the challenging of due process, they haven't perfected service nor the constitutional requisites necessary to obtain jurisdiction. Until such matter has been perfected, the court lacks to hear any motions, any pleadings by the prosecution until such matter has been perfected.
Okay. So a lot of people use special appearance when they go into court. They say, I'm specially appearing, and it does nothing. So how do you remedy that?
This is why I just said they didn't perfect. So due process, they must perfect due process. Without the perfection of due process, nothing can be done. The court can't hear it. And the court trying to still move without the perfection, then the judge become liable because they acted outside of the gamut of their authority. They don't have the scope to do that. The prosecutor must prove that he perfected due process.
So what would you file? Like, what would you file, or, what is
motion to dismiss, or motion challenging the jurisdiction based on the constitutionality of the case, that the court hasn't perfected constitutional requisites to be able to enforce this matter.
There we go. Okay. Gotcha. Granted, when
made by a party to an action, but before the service of any process or legal notice to appear, a deed being essay made when made previously or remain good only upon a future contingency or when the court permits a party to a proceeding to refuse to submit his person to the jurisdiction of the court unless it is finally determined that he has forever waived the right. I gotta listen to this stuff. We talking about appearance. Subsequent, when made by the defendant after an appearance has already been entered for him by the plaintiff. So, corporal, when the person is physically present in the court. Answer, constitute an appearance. A answer constitute an appearance.
An answer constitutes an appearance.
Yeah. A party answers consent to a continuous go to trial, takes an appeal, or does any other substantial acts in a cause, although he has not been served with the summons, is deemed to have entered in his appearance unless he objects and preserve his protest to the jurisdiction of his person. So let's talk about a notice of protest. Now, this is what we're talking about. You see it. Unless he objects and preserve his protest to the jurisdiction of his person. Do y'all see it? So this is why we're doing the petition. And once you get everything together, we do a petition. We do a notice of protest. In conjunction with that. So I want to just go, it's appearance by notice. So it says appearance day, the day of appearing, that on which the party are bound to come into the court. Appearance docket, a docket kept by the clerk of court in which the appearance are entered, containing also a brief abstract of the proceedings in the case, right? Notice of appearance. Most of y'all do not do this.
Oh.
Before you enter in any court, you're supposed to tell them how you're going to appear. You can do a notice of non-appearance due to the non-perfection of jurisdiction based on the Constitution.
So it's got to be in the form of a notice, right? Are you saying?
Yeah.
Because I know a lot of times they put in there, like in their motion, they're putting specially appear, so specially appear.
Listen, everybody, okay, before a prosecutor, before anybody can take the case, like let's say you got a civil action. I was going to child support. I remember I kept hitting my baby mama lawyer with this. I told the court, he can't speak. He never filed a notice of appearance. I got to know who's appearing on her behalf because he's acting as the agent for my child's mother. So right. I'm striking anything he said for the record. I'm asking the court to strike it. The judge was looking at me like, he let him keep talking. At the end, he let 2 hearings go by, and I was objecting and striking everything he was saying. But the judge kept doing this bull crap. And he kept telling him to file a notice of appearance. I said, Your Honor, we had 2 hearings. You told him to file a notice of appearance. So I'm objecting to anything that he's doing. Every motion that he ever filed, any pleadings or anything that I'm asking you to strike it from the record. The judge knows that I was giving him a hard time. Even with the prosecutor. You don't know if that's a real prosecutor. You don't know if that's a fake prosecutor. You be like, Your Honor, I need him to put his credentials on the records and show a notice of appearance by this court so that I can know who I'm probably dealing with. The prosecutor haven't put in a notice of appearance. So I'm not going to presume that he's the prosecutor. He could be a fake lawyer. I haven't checked his credentials. Do we have an oath of office? Do we have anything that we can substantiate that he works for the state? And he's acting as an agent for the state.
Right. So, hey, so you just see the comment on the screen?
I gotta come back to it. What it says.
Oh, okay. It says once a civil matter has been settled with prejudice, can we refine an can we refine in another county district court jurisdiction?
I don't even know what he's asking.
I'm trying to think. Can we? What do you think?
If a court, just think about what he asked. He said if the court has been settled with prejudice, that means it had to be dismissed with prejudice. And then he's saying, can we refine in another jurisdiction? No, it's been done with prejudice. That means you can't bring that claim again. Period. Now, if it's without prejudice,
right.
The court will allow you to amend your complaint and stuff like this. That's what I'm saying. When you're not using the proper language, the court will look at this and say this is frivolous. They don't know what you're talking about. So he wants to use it. Once it's been with prejudice, that means they're blocking you from using that same subject matter. You got to come under another application.
Ashe? All right. So
I'm just telling y'all, also appearance, right? I want to show y'all. It says appear in practice to be properly before a court as a fact or a matter of which it can be noticed, to be evidence, to be proved. I want y'all to understand that. You don't appear into the court as a matter of fact or of evidence which can take notice, to be in evidence, to be proved. Making it appear and proven are the same thing.
To appear
in you hear that?
Y'all hear that?
Making it appear and proving are the same thing.
Right.
You got to make them prove jurisdiction. And how do you challenge that? By the constitutional, that they failed to meet constitutional requisites and that the court lacked jurisdiction. Without perfection of the constitutional requisites, they can't hear the case. Period.
That's right, y'all. That's right. All this
when you don't know these things, you can't do these things. So I just want to go over that. So the only time you can appear in court is when they can prove it or they can hear you. Just because you show up in court, that don't mean they gonna hear you. That's why you ever heard somebody say, or the court asks you, is you this? And you saying, well, I'm this person. The court, I keep asking you, are you John James? And you say, I'm making an appearance for John James. Are you John James? I'm going to say it one more time.
Right.
Then they hit your ass with a failure to appear. And you were there. Because it has to be proven. It got to be by evidence, and evidence alone.
That's right.
I hope everyone is getting this. We are the pro se Moors. We're dropping this knowledge on y'all so y'all can get better acquainted with the law. Because we know ain't nobody teaching y'all like this.
Nah.
Not
so,
like
right. Nobody hitting. So we're going to take a quick ad break, real quick, and then we're going to come right back into the next segment. You guys, I know you got something else that you was gonna deal with, right?
Yeah, I want to break down defenses and objections.
All right, we're gonna be right back.
Books on the shelf, knowledge on display for the conscious minds every single day. History and culture, the Moorish way, woken aware, let the melody play. African center, lifting up the crew, pages filled with power, showing you the truth. Moorish and aware, reaching for the stars, woken every sense, breaking down the bars.
All right. So we back in the building. So this is the second half. If y'all just tuning in, please like this video, share this video, and please subscribe to the channel and check out our other videos we've done. Check out the past episodes of Pro Se More. This is the 6th episode, so y'all can check out our other videos. So now let's get back into what we want to finish up when we're talking about this motion pleading. So, we've been dropping some jewels. Like King been dropping some jewels on this dealing with the motion pleading. A lot of misconceptions. I hope y'all are starting to understand. So, let's get it. So where else were you gonna go with this, brother?
Oh, we're going into defenses and objections with how to present motions for judgments on pleadings, consolidating motions, waiving defenses, and pretrial hearings. We're going there, baby. We're going there. Do you want to go there?
We pro se moles, man. All right, let's get it in. All right.
Man. We're going to have some fun. Defenses and objections when how presented. Motions for judgment on the pleadings, consolidating motions, and waiving defenses. So a lot of people be trying to use what they call an affidavit in defense. So that's what goes with your motion in support. So some of that affidavit in defense can be utilized in traffic court for when you don't want to appear. You can plead guilty, you can plead no contest, all that. So you don't have to appear to court.
Would this work for a warrant if you got a warrant out?
No.
Okay. I ain't think. All right. Let's do it. All right. So
when utilizing an affidavit of defense, like if you got a traffic, you don't have to appear. You can just put in your affidavit of defense and put that in, and then the court will make a determination like on your would. So a lot of us be going down to arraignment when you don't have to. You just put an affidavit of defense. Submit it. A lot of times they want.
You say affidavit of defense along with your motion of.
You don't have to necessarily put in a motion, but you can just based on your plea, and then that should be substantial enough for you to, unless your state waives such application of defense. So check your state laws before you do that. It says time to serve a responsive pleading. In general, unless another time is specified by this rule or a federal statute, the time for serving a responsive pleading is as follows. A defendant must serve an answer within 21 days after being served with a summons and complaint. If it has timely waived service under Rule 4D within 60 days after the request for a waiver was sent, or 90 days after it was sent to the defendant outside any judicial district of the United States. A party must serve an answer to a counterclaim or cross-claim within 21 days after being served with a pleading that states the counterclaim or cross-claim. A party must serve a reply to an answer with 21 days after being served with an order to reply unless the order specifies a different time. United States and its agencies, officers, and employees sue in an official capacity the United States, a United States agent, or a United States officer or employee sue only if an official capacity must serve an answer to a complaint, counterclaim, or cross-claim within 60 days after service of the United States Attorney. So, I use this rule even in criminal matters. So one time I got a traffic ticket. So I tried to serve it under the traffic rules because they say you can file. They tried to tell me I couldn't. So a lot of this stuff, because you got to remember, right? There's only one form of action that shall be known as a civil action. Action. Civil action. So when we're talking about action, I want y'all to understand there's no such thing as civil jurisdiction. Right? Hold on one second.
All right.
Take over for about 1 minute.
All right, y'all. So I know he was getting into his spiel, but another aspect of what we're going to be dealing with too, because we're talking about pleadings, we've been talking about motions and pleadings. The other part of the pleadings that we're going to get into is going to also be about the plea bargaining. And so I know he's going to get into that too, but I'm just going to mention this though. You know, we're talking about pleadings, pleadings, and plea bargaining. A lot of times what happens with us when we go to court is we wind up being railroaded through and then wind up taking a plea bargain. And then once we've taken the plea bargain, that plea bargain has sealed our fate with the case, right? So let me see something. So I'm gonna get this real quick. Why he get back to that? Because this is I wanted to get into this spiel. We talking about plea bargain, all right? Plea bargain. A plea bargain, also known as a negotiating a plea, is an agreement between prosecution and the defendant, where the defendant agrees to plead guilty to the charges against them. A plea is a criminal law term. Understand that. It's not civil. It's a criminal law term referred to the accused individual's former responses to the alleged crimes, which could be guilty, not guilty, or no contest. So, you know, we know these three choices they give you are really not choices, right? Especially, you know, when you're talking about no contest and not guilty, right? But it's important in pleading that we don't necessarily take these plea bargains, because these plea bargains can cause a lot of more damage and they're permanent, right? You back, brother?
Yeah, I'm back.
Okay, you go ahead.
I heard you talking about plea bargain. So remember, please, right?
Right.
When you make a plea, you waive all known or unknown defenses.
Exactly.
So you waive any of your rights. You waived your rights because you made a plea. So now, once you've been proven guilty, you can't come back and sue. You see what I'm saying? Because you did it on your own recognizance.
Yes,
Right?
exactly. Right.
So I hear you. All crimes are commercial, depending on what agency is bringing the crime. Right? Is child support a criminal? Is a commercial action? Is child support? You need to ask yourself: is child support a commercial action? Is you going to jail for committing some kind of commerce crime?
I mean, are you? I mean, it could be argued that.
You're dealing with private law. Family law is private law. How could it be commercial?
I mean, you dealing with? Are you not dealing with commerce? Are you not dealing with any type of financial?
You dealing with financial,
Okay.
but is it a
Is it
commercial?
commercial?
Right.
Right.
So
Right.
most of the time, what you're going to jail for is contempt of the court. You're not going to jail for not paying. You're going to jail for
You're
contempt.
right. I got you.
You see
I
what I'm
got you.
saying? So why are you going to jail? You got two forms of contempt: criminal and civil contempt.
Civil. Right.
Right? So the court is hitting you with a civil contempt. Criminal contempt is something that you did in front of the judge. But civil contempt is where you are not obeying a direct order of the court. So you got a child support order. You're not going to jail for not paying your child support. You're going to jail for contempt of the court. That's different.
But what is the contempt of court for? Like, generally, like, what is?
So the court ordered you to pay child support. So here's the tricky thing. Here's the tricky thing. They did a child support calculation to determine that you supposed to pay this much. This is how a lot of brothers go to jail. They don't even pay anything. Most of the time, if you gave them $5 a month, they won't even suspend your license.
It's right.
You're
right.
You're paying the court order. You're not paying the full amount, but you're paying. You can't go to jail for compliance of the court order.
What if the court order saying that we want $120 by the 15th?
That's a direct order.
Right.
9 times out of 10, the mother has filed a contempt. You are contempt of court. That's what you're going to jail for: contemptuous behavior, of contempt of the court. Contemptuous. You're being contemptuous. You're not obeying the law. So what happens is that you go to jail because the judge now want $120 by the 15th, and now you're not compliant because you wasn't compliant in the past. But if you've been paying $5 a month, and you're saying this is all I can afford for whatever reason, they can't hold you in contempt. You might not pay the full amount, but they can't hold you in contempt.
Okay. All right. So, going back to all crimes is commercial real quick. I mean, I don't want to get thrown off on that, but all crimes are commercial. And then you saying, well, all crimes maybe are not commercial? Is that what you're saying?
Yeah, depending on the subject matter and the classification of the law, then it's specific to the jurisdiction. So you have to understand all the things like family law, right? That's dealing with private law. That's dealing with private rights, right? So based on like, for example, is a will dealing with commercial? If your father died or my father died and he was a will, is that commercial?
No, I mean, it's probate. That's private law, right?
So, right. So we got to look at the context of what's going on based on the subject matter and the classification of law, based on the category of law, right? The category of law. This is why I try to tell people law is put into categories for a reason, so that you can properly identify how to think proper when you're dealing with these specific jurisdictions, right? When you say anything. So it says all crimes are commercial, all crimes, but not all law is commercial. So 9 times when you're doing a crime, the contempt, is that considered criminal? Is considered contempt of the court. So that's a civil matter. It's not a criminal matter. It's a civil.
Right, but civil is not criminal.
Huh?
I said civil is not dealing with criminal.
Right.
So I mean, so they're not. So we know that they're not talking about civil, but we're talking about if we're in criminal court.
If you're in criminal court, of course you're dealing with
So we dealing with criminal law. So is that meaning that at that
all
point,
crimes, yeah,
all crimes are commercial?
Right. When you're dealing in that aspect, but I'm just breaking down the differences because everybody think everything commercial. Some people think child support is commercial, all this, everything. No.
That's true. That's true.
So, no, it says all crimes. You got to look at the words. You understand the substantive language and what it's speaking on, and the subject matter. It's talking about criminal. So when you go to jail for child support, that's civil contempt. That's not criminal contempt.
All right, so let's look at this real quick. I mean, because I know we getting up, but it's good. It's good that we got these questions, y'all. Y'all got questions. You know, dealing with things. We're gonna try to hit them real quick. You know what I mean? So they say my situation was a kidnapping of my person, and the same day, I was held in contempt for 5 months for stating my nationality name out loud. Now I know it's got to be more than that. But okay, based on what you've been saying, what do you got to say about that, King?
It got to be more detailed information because it's. I mean, he's saying that he was kidnapped. You know, a lot of brothers.
So kidnapped? What you mean? He was arrested?
Yeah, that's most of the time they was arrested.
You was arrested, right? I mean, I know you're saying kidnapped.
The same day I was held in
arrested
contempt.
The same day because you was held in contempt. So you was held in contempt just because you said your national name out loud?
No, he was probably held in contempt for something that he already had a warrant for, or something involving a case, right? In which then the court then held him in contempt, and he probably was still talking, and he was saying his nationality, but he didn't understand what was going on, so he assuming it was based on his nationality, but it was based on his behavior not to adhere to the court. So
Drop us a little bit more. Drop us a little bit more on this, y'all. Brother, what's your name? I want to say Rashid Malik. Right, Rashid. If you could drop a little bit more understanding on that, so we could get a better picture. Because I'm gonna tell you like this: as pro se more, and when we hear a lot of cases, a lot of people give us an extended remix of what really happened. Okay.
Remix.
Yeah, they do a bad boy remix of what really happened because, like, you know, they're giving us a certain version of what they want us to paint a picture of, and that may not exactly be what happened. And I know that happens a lot of times. A lot of times, like I said, we have these misconceptions of law. So when we going in there, it's crazy. But I'm not saying that you know, I'm just saying, like, I know from previous experience, like how things go. So the origin of the matter was several years ago. They claimed my person had right. There it is. There it is. Right. So they had a warrant. You said it. You called it. You called it. You called it, brother. You called it. So that's the thing, y'all. You had a warrant. So did they kidnap you because you had a warrant? Did you have nationality back then when you know what I'm saying? Like a lot of people come in here. Okay, Rashid, I got you. Thank you. Give thanks, Rashid. But a lot of people come in here with like previous crimes that they did. I won't say crimes, but incidents that happened that they were going to court for, and then they come and get their nationality or claim their nationality, and then they want to go back and try to deal with it from that perspective. But like we said earlier in this podcast, that you guys are already in their jurisdiction. Like we've all been born into this jurisdiction one way or the other. You guys can claim this and that, but we were all born in here. We all got social security numbers, right? We all got birth certificates down there. So trying to find a way out of jurisdiction is not going to be easy, and you haven't done it yet. So I just want to put that out there.
There's just so many misconceptions about all of this. And one day we're gonna break down the 14th Amendment and really break it down, because there's treaties involved in why the Constitution was constructed the way it was constructed. That's for another show, but I think we'll bring Abdullah in and all that have the powerhouse, and probably bring Shem and all of that in there.
Right, we probably gonna do a show. We go like we got them anyway. They gonna come on and do a show anyway, so they probably do a show like that anyway.
Right. So
y'all check them out. But
we're gonna break some stuff down. So, like I told you, it probably I told you it had something to do with a warrant. I called it because that's what it sounded like to me. What y'all like to do is y'all want to claim nationality as a get out of jail free card, and it's not gonna work.
Yep.
Nationality ain't gonna get you out of jail. So this is why it's a lot of pseudo law, a lot of pseudo practices. So when we talk about these motions and pleadings, right? Let me get back into that, right? So we can break this down. Because a lot of y'all is just, man, I don't know. Y'all so all over the place. I don't know how y'all gonna get ahead with everything that you're doing. So effect of a motion, unless the court set a different time, serving a motion under this rule alter these periods as follows. If a court denies the motion or postpones its disposition until trial, the responsive pleading must be served within 14 days after notice of the court action. Do you hear me?
Right. Did y'all hear that? See,
so a lot of your motions get out of time.
Exactly. I was just about to say that. Y'all are not following the rules. Y'all are not following the rules. So I'm going to put this up. So you talking about this right here. I put in a previous clerk administration of notice by way of declaration of indigenous inhabitant. Okay, so let's go back. Let's go back a little bit. Because we discussed, right. We discussed how you gonna have to put that in there earlier, right? I mean, if I'm trying to remember, we was talking earlier about filing like jurisdiction, like the jurisdiction being in your special appearance.
I talked about a notice of protest.
Right, notice of protest.
I talked about it. Said it in the rule. Either you object, and then you either put in a notice of protest.
Right. So did you properly? So even though you put in this notice of declaration, did you protest? Did you object? And did you protest it? And the answer more than likely is no. You put that in with the assumption that is a protest, with the assumption that you are not, you're saying your special appearance. So these things are done like a little bit.
So let me ask him, what was his proof of evidence that he was indigenous, that he's an indigenous inhabitant? Where's the proof? Do you just say, oh, my affidavit solidify and that makes the proof? No. You have to use what they call findings of facts. So where's the indigenous population that identifies you as a member of that group through some type of institution, organization, or whatever that can solidify that position?
Right. Y'all going in there by yourselves. Y'all the nation of one. Y'all the nation of one. Going in there.
That's why we putting a petition together. Elements that's necessarily needed. That's why we killing all the misconceptions, man. All this status correction bull crap, all this secure party bull crap, all of that other stuff that y'all doing, that stuff that it ain't got you nowhere. So why you keep doing it? Now I ain't gonna tell you that's not. You can't have a security in property, have a security agreement. I'm not telling you you can't have a debtor and creditor relationship. But that's all done through contract. We're talking about contract law. We deal in estate planning. I show you how to do that through estate planning, through obligations, identifying the parties as an obligor and an obligee in a relationship of contractual nature. We're gonna break this down. If you really want this stuff, me and Chief we got the remedy.
We've seen a lot of different scenarios. You know what I mean? Through, dealing with different people, dealing with different cases. We've seen a lot of different scenarios. We've seen brothers coming in using what we call sovereign citizen, or even like modification of Moorish science, like techniques, right? We've seen that. Brothers call us talking about Tariq Bey and all that, like what he said to do, right? But they calling us because it's not working in court, because their ability to apply it is difficult, because you're missing the key components of law and the rules to do it. You guys are trying to make up your own thing and trying to force the court to accept it. You're trying to get the court to accept it based on your understanding of the law, and that's not how it goes. So this is why tonight, like, we're dealing with this. We're dealing with the with pleading. So we're trying to show y'all, because like we said, y'all missing the point of motions. You're missing motion pleading. You're not filing any motions. Like even brother Rashid, I'm not sure you filed any motions and to get this going. You see what I'm saying? I'm hearing declarations, notice, things of that nature. I'm not saying a notice is bad, but what I'm saying is I'm not hearing the all the components that are needed to have effective communication with the court system. Okay.
And that's what I talk about, effective communication. You heard I said it 1,000 times on a lot of my videos. Effective communication. They lack the ability to effectively, because they're not procedurally sound. They don't know the application of law in which they're using. In Pennsylvania, the Constitution, the first article states and explains that people are inhabitants of the land.
So, okay.
So, first of all, we got to understand that the Constitution, they got two principles. They got constructive and original. Right? So, when you look at a Constitution and the constitutional meaning, based on the things, they got principles of construction and the principle of original. What was the original intent and what is the constructive intent, right? When they talk about inhabitants, what does that mean? First, you got to understand that component. These are complex situations, but that can be simplified if you understand what you're looking for when defining, because we talking about terms. So this is why I try to tell people some things in the Constitution are left unfounded or do not have a term to explain it. So when you go look at, so let's go here, like to the Pennsylvania. Don't you know they got constitutional minutes? Have everybody looked at the constitutional minutes? Have you looked at the constitutional minutes of Pennsylvania? Have you called the Library of Congress or your state assembly, or what is it called, your General Assembly, to look at the constitutional minutes of that state constitution and read through it? Have y'all did that? Like, have y'all looked at, even with statutes, have y'all looked at the trust minutes or the minutes of the stat. Like when they make a statute, I want y'all to understand. You must ask for it. You can go to the General Assembly and ask for the minutes so you can determine the purpose and intent of that statute. To challenge the court on how they're using the statute. If the prosecutor is properly interpreting the statute, because if you don't know what the intent and the purpose of that statute, and he charging you with that, how are you going to know if he's using it incorrect or not? If you don't go to the minutes, right, of the statute.
Mm. Mm.
And every assembly, you might have the 31st, the 29th, the 22nd assembly. They pass these statutes. And every statute has what they call minutes. They call not constitutional minutes, but they have you can ask for the statutory minutes associated with the that statute. So you have to. There's so many things that y'all ain't doing, and I know y'all not doing.
Right.
So
I guess.
this is what we do. Come on, Chief. Come on.
Let's get it. So I got the brother Tariq saying, I literally have no idea what Moors are doing. Why are Moors under the jurisdiction of Europeans? Now, I don't understand why you don't understand how Moors are under the jurisdiction of Europeans.
Moors are not under the jurisdiction of the Europeans. Here's the issue. You're not identified as a Moor, and they're not recognizing you. They recognize you as black, Negro, and colored. Until you have a Moorish government that recognizes you as Moor, and other nations recognize that as a nation, you ain't gonna never be identified as a Moor.
Right, but that's what he's saying. I mean, but that's it. That's it. You're not. Moors are under the jurisdiction of Europeans because they haven't established their government. That's why.
And is a particular way you have to establish government. And the way Moors are doing it is not at it. And if you got an EIN talking about you're a government, you're a fool.
Right. And the fact that, right. And I feel like they're in violation of the treaties because we're not a government to establish or to counter that, to argue that, to protest that as we talking about. We're not protesting these things. We don't have a government to do that. So it's hard for the Moors that are claiming themselves to be Moors and trying to fight it because they don't have the provisional government to protect them and to basically conduct this, in my opinion.
Right. So one of the things, that's why I say, when you understand the application of law sovereignty, they got elements that you must meet or requisites. And when you don't meet them, you can't substantiate your claim because you never perfected that claim because you never met the elements or the principles involved with creating a provisional government. And if you don't know these principles and you don't know these elements, you ain't gonna never get there. So that is one of the problems. They're saying, everybody say they're in violation of the treaties, but no, we are rooted in misconceptions and pseudo law that we don't know what steps to take to ensure the Moorish protections by following the proper application based on the principles, dealing with the proper elements to say that we met that criteria and how we can perfect our claims. We're not doing that.
Right. So look at it. Yeah, okay. Oh, okay. So you got some books that tell you a Moor and you're not a Negro. So are these books used for law? is the court? Do the courts identify you as Moorish? Do the courts identify you as a Moor? That's the question.
The courts are not acknowledging these people as Moors. That's why they're doing it. So you got to.
But even if you got them in a book, I'm saying even if it's in a book, y'all got them in a book. Are you able to solidify? Are you able to take that evidence of a book? That's evidence. Are you able to take that into court and have them recognized? That's the issue. I mean, like, what I don't understand. I don't understand why you think that that's the answer. Like, I'm not sure. Didn't Hoover take the council away? That's a good question. I'm not sure if was it Hoover that did that. I mean, I'm gonna tell you like this: when you look at what happened with the Moorish Empire, the Moorish Empire is still there, but they created a Moorish kingdom, the Moroccan kingdom, and when they did that, when the Moroccan kingdom, when Morocco was under French, when they were under French conquest and all that. I mean, that's when you start seeing the consulates disappear in the United States.
So this is what happens, right? So you got to understand a dissolution, right? A dissolution, that's another term or element when you disillusion a trust. We got to understand the collapse of a trust, right? Trust collapse. We got to understand certain applications of law, abandonment, right? So the trust was abandoned, right? So abandoned, that's just like, okay, for example, let's say if you have some rights, let's say your mama left you an estate and you abandon that estate, right? Do state just supposed to let that property sit there while you run around the country and don't come back and handle those affairs? Or do the state say, okay, they got this house, they got these other things, these are unresolved matters, and the house now is starting to become a nuisance because crackheads are breaking in, stealing, they're living in the house. Now it's vacancy laws and all types of other laws associated to keep that when people abandon property. Because people abandon property all the time. Like what happens when your car break down and you don't come and get it it's on the side of the road of the expressway? Are they supposed to leave it there until you figure out what you do with it? So that's what it's like when you're talking about the Moorish Empire. It's been abandoned. Right. But we can come back and claim it. Right? We can come back because it's been abandoned because what happened was they violated the treaties and they violated laws, right? So one of the issues is when you're dealing in war, the application of war and peace. After war, under international law, you don't supposed to strip that nation of its nationality. You're supposed to make them whole after the war is over. You're supposed to make them whole again. Allow them to go back to their way of life, even if they come under a dependent state of sovereignty. You're supposed to make them whole again. What happened is what they did was they stripped us, took us from our national origin by stripping us of the language and our national identity, so we cannot come back to the fold of treaties. So that's also genocide in a nation. That's forbidden under international law. Subjugation is forbidden under international law. Cruel and unusual punishment is forbidden under international law. All of those different things, right, are under international law. And what's happening is nobody is claiming it. They're arguing slavery matters, and slavery is not a term that's used in international practice or in domestic law.
You say slavery is not used in international practice?
No, that is not a term.
Okay. What?
So if you say slavery, there's no international term for that. So you can't get no relief for slavery. But if you say subjugation, right? Can you still hear me?
Yes.
I don't know why I'm froze, but I'm froze. It
You
seems
did.
like when I get to talking about certain things, I freeze up.
They got you. They got you. So he'll be back on here. I'm sure he'll come click back on here in a hot sec. There we go. You back? I can't hear you, my brother, but we got a lot of questions popping up. You feel me? A lot of questions popping up.
Shade is back. Tell a friend. Guess who back? Guess who back? Guess who back? Guess who back? Na 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 na.
Boy. He go, hey y'all, he gonna talk about some Eminem. You know what I'm talking about? Y'all, he crazy. No albions. You know, hear me? You know what I'm talking about? But what you talking about? Jay? Website not working. Which website? We got the indigenous.moors.org. That's what you need to be on. indigenous.moors.org. It should be that. I know that's working.
Yeah. I don't know if the emissary, I got the emissary, it's not working yet.
Right. Now the other one, if y'all on the indigenous services.webs.com, if y'all on that old site, like that website, we had to switch sites because I don't know, that website no longer is working. That website is no longer in business. You know what I mean? So we on indigenous.moors.org. Y'all jump on there and check things out and get acclimated if you want to check things out. But we got a lot, like I said, we got a lot of comments. You know, everybody comment now. Everybody want to comment.
Bring them.
So my thing is, they talking about like one thing. All right, right here. I wanted to talk about this one. Dred Scott. They talking about the Dred Scott case. He lost because he was a plaintiff in error, right? Because his legal status was Negro, of course. Now William Dungy, which we talk about that if y'all get the book, the Moorish Treaties book, we discussed William Dungy's case with Abraham Lincoln. Said he was a Moor, not a Negro, and he went free. So are we? I totally get it. There are several cases back in the late 1700s and in the mid 1800s that deal with Moors, and the government seemed to acquiesce with that, right? But that was then. We talking about now. So we said, like we were saying, the consulate in the Moorish Empire. Like now we got
so that's what you got to remember.
Morocco, right? We got the Empire of Morocco, but which is still here, but it's been deactivated in a sense, right? And then they reinstated, they put in place of that the Kingdom of Morocco. The Kingdom of Morocco, they changed the name definitions of what they don't even talk about Moors in the Kingdom of Morocco.
They call themselves Arabs.
Right. They call you Arabs. They call people Arabs, and they call black people black. So they changed due to conquest, being under the domination of French. They changed. So now when you go to court, you can't get that remedy as easily because they have hid it. So that's why you're having a problem with looking at 1800s, late 1700s, and you're looking at 2024. They got a whole different thing jumping off. So go ahead, brother. You go ahead and explain.
So that's what I'm trying to get Morris to understand. Look at the timeline. Look at the sequence of events that we need to explore that. Those treaties were active then in the 17th and 1800s. Those treaties were active. What make these treaties inactive? When in 1956, the Kingdom of Morocco was birthed.
Right.
And under letters to the United States, they said they will not use the term Moor. They will use the term Arab. Arab is defined under those treaties, not Moor. So what has happened based on a new regime, based on the birth of a new entity under a new state, the Empire of Morocco is now asleep. It's deactivated. It's been abandoned. I want you to say the abandonment of rights. So once rights have been abandoned and they're not claimed, guess what happens? They can't be enforced. And the reason why they talk about slavery and they did it so hard and they did it so much and to rename you and reclassify you so that those treaties are now cannot be resurrected and be enforced, and to miseducate the people on international law so they can't reactivate those rights. So y'all got to understand this stuff, man. Y'all are saying things and y'all don't understand treaty relations. You don't understand these things because treaties and international studies and understanding fundamental rights is very important. And a lot of people don't even understand how the Constitution was constructed off of treaties. So Dred Scott, when they talk about he was a plaintiff of error because they were saying that he identified himself as Negro.
Right.
He identified himself as a Negro.
Right.
And he never protested against that. He didn't put in a notice of protest. Right?
No.
Because why? He was incompetent in law. Because if he knew what to do, he would have knew how to lay out his claim to perfect.
Even more. I don't think he knew Moors. I don't think that he saw himself or understood himself as a Moor.
Exactly.
And like we keep saying, we talking about in the 1850s, like somewhere like 1850s. So we're talking about the consulate courts were still in place. The consulate courts were still in place. The Empire of Morocco still existed in the 1850s.
Exactly.
You understand? So that's the problem. The Empire of Morocco was still active. It was still activated. So that's why y'all got to get out of the time frame. It's like the law that y'all using is not applicable to today's standard of international, under the international laws now. Like Morocco is being identified as the Kingdom of Morocco.
Right. But they don't understand abandonment of rights. Look up hold on. Let me look up. Let me look this up.
Yeah, go ahead. I'm gonna put it in the thing. Abandonment of rights. Y'all, please smash that like button. All right, and please share this video to y'all, other Moors and other brothers of conscious minds. Share this. What you say? Abandonment of rights.
Yeah.
Hope I spelled that. Yeah, let's go. Let's show. So we have abandonment of rights. Go ahead.
So do you want to share the screen or do you want me to share the screen?
When you share it, I mean, it's not up yet. I don't see it.
I'm saying, I was asking you, did you look it up and find it? I found several.
No, I mean, there you go. It just popped up. Okay.
So let's go over here. Let's make this bigger. I want y'all to zoom in. I want to zoom in on things so people. This is why I keep talking about operation of law, understanding certain things, man. Like y'all don't know how the law is supposed to operate. So Martial abandonment. In law, the term abandonment may be used in a variety of legal issues, from contract law to real estate law, refer to giving up or renunciation of an interest, privilege, or possession, or right with the intent of never reclaiming it. As the term applies to a matter of family law, an individual may abandon a marriage, spouse, child, or property. While abandonment of marriage or marital property is a civil matter to be dealt with within family court, abandonment of child may also be a criminal offense for which the individual may face criminal charges. To explore the concept, consider the following martial abandonment. So I want you to look at what it says. As the term applies to matters of no. It says from contract law to real estate law, referring to giving up or renunciation of the interest, privilege, or possession of a possession or right with the intent of never reclaiming it. Did y'all see that?
So we abandoned it. Our forefathers, our ancestors abandoned.
No, they didn't abandon it. That ain't what happened. They subjugated us. It was forced.
I mean, I understand what you say. Yeah, I mean, we were forced into that, but I'm saying we never picked it back up. That's all I'm saying. We never, like, before what? When the Moorish Temple come into play? 1920s. When the Moorish Temple came into being, Morocco was under the French. Morocco was under the French around that time. I know you done froze up. Brother Tariq, I'm agreeing with you. I can't hear you, King. Oh, you muted. You're muted for one. But Brother Tariq, I think you're saying the same thing in a sense. I'm saying they still are holding us under the status of Negro and Black. You are correct. They are still holding us under Negro and Black. I think we agree with that. They are holding us under Negro and Black. That's part of the problem that they're doing that. Okay, go ahead, brother. You there? I can hear you. You froze up. But
okay, you can still hear me though, right?
Yep.
So the issue at hand is that when we looking at the term abandonment and relinquishing of this, right? We have a unique situation. We were subjugated. We were subjugated under their laws. No, the screen ain't even moving. We were subjugated under their laws. They stripped us of our language. They stripped us of our nationality. And so that we couldn't. They never made us whole again. So by them failing to follow international law, what they did was that was cruel and unusual punishment. Right? That was cruel. Right. So now there was genocide of a nation. Not only was it genocide, but it's also subjugation. Right? So they can use they can try to use it, but we can prove that it was forced upon us, that we were beaten, killed, maimed, hurt, injured by every means of harm that you could think about. So through those applications, we can't use the term slavery because it's not an application under international law to recover for reparations. The Jews, the Germans, nobody used that. The Jews didn't use slavery. They didn't use that term. Anybody who, if you look up international law cases for Japan, nobody used the term slavery. It's not a term to be used under international law. You still there, brother?
Yeah, we still here.
So that's why we can't get any relief, because we don't know about how international law works properly and how everything's supposed to go.
Right.
So that's just the bottom. That's the bottom line. That's why we put in the petition. That's why we using everything and putting it back in proper application, so that we can perfect the application to get the relief that we need. Got to perfect the application.
I'll say Islam. Yes, sir. Yes, sir.
So who else? Come on with the questions. Let's go.
They got what was the other question? Okay, he got the one here. Negroes, right? We understand it, right? I mean, you're right, Tariq, brother Tariq, on that. The Negro was forced on our ancestors after Boabdil surrendered Isabella, right? And Ferdinand of Granada. I mean, they're the one, like, and that's facts. I mean, like, when they talk about the word Negro, that word Negro is Negro, and that is Spanish. So they're the first ones to subjugate us to, these names that are outside of our status. So yes, I mean, we agree. That's what I'm saying, brother. I'm like, Tariq, brother, I agree with you on everything you're saying for the most part. We saying, like, how do we reinstate these things in court? Because we can't do that. It's like we're looking at the past and we're looking at the laws, but they're not adding up to what's going on right now. Because we're looking at 1800s. And we're trying to use 1800 applications to facilitate 2024. You see what I'm saying? So, brother, we got to get. Hey, I would look, brother. See, we have to get into that on the next video because we kind of running up to our time.
Yeah,
that would be an excellent topic we would have to deal with. And maybe we'll deal with that when we get with the other brothers as well. We can talk about the Washington French connections because we do also have the arguments of the indigenous aspect of Moors in America here. So that's a whole nother piece of the puzzle because all we really been talking about was the Moroccan side over there, with the Moroccan. But we really haven't touched on the indigenous aspect of the Moorish science. You see what I'm saying? So that's for a whole nother show. We kind of got off, with the motion pleading, but I think that y'all needed this. I mean, obviously you guys had questions, and we here to answer these things. And like I said, if you got any more questions, then you can always go to indigenousmoors.org, and you also have our. I'm gonna put our banner up real quick. If you check out, you can also reach us on indigenous.moors.org, or you can reach us at 513-486-6115 for any other info. Or if you got legal issues that you're trying to understand, we will be able to assist you in that. So, we hope that you guys understand a little bit more. I hope that was constructive. And I think we can pretty much wrap it up tonight. Is there anything else you wanted to add before we left off the scene, my brother?
No, my brother. No, my dear brother. We are finished. Wrapping it up. So, thank for everybody for watching the show. We got the new book coming out, The Principles of Law, the DNA of the Legal System. So I got more books coming. Go buy the book. If you got child support issues, go on Amazon and hit the book, How to Stop Child Support. Listen, I'm about to do some more stuff specifically for child support remedy. Listen, I'm your guy for any child support matter. I don't care what it is. We're going to get the child support issue handled. We're going to kill the child support. So call your boy. We got some stuff jumping off. So we're done for the night. I have no more to say. Peace. 229.
Oh, I hear you, brother. 229. All right, y'all. We're going to get back with you. I'm going to hit y'all with this, and we out. Peace.
Power in the melanin, she glows. Unified like Malcolm when we close. Pushing through the struggle, yeah, we chose. Solid as a rock, I love it grows. Speaking wisdom just like Dr. Umar knows. Dripping culture in our stance, it shows. On the front lines where that passion roars. Building empires, Kevin Samuels goals. Sitting at the table, he proposed. Melanated love, in America it flows.